Thank you, Officer. Second case this afternoon is Biomedical Applications of North Carolina, Incorporated, doing business as BMA of South Greensboro versus NC dhhs, Division of Health Service Regulation, Healthcare Planning, and Certificate of Needs section. Let's go ahead and begin. Counsel, you may approach the lectern.
Thank you, Ron.
Would you like to reserve time for rebuttal?
Yes, ma'am. 8 minutes, please.
8 minutes?
Yes, ma'am.
Okay. You may proceed.
Thank you, Your Honor. Good afternoon. If it please the court, I'm Mark Hewitt, and this is my partner, Elizabeth Sims-Hedrick. We're from the Raleigh office of the Fox Rothschild Law Firm, and we represent the petitioner appellant Biomedical Applications of North Carolina, Inc. In this case, Biomedical applied for a CON, a Certificate of Need, to move some of its dialysis stations from one location to another to better serve its patients. It proposed to use its own stations and spend its own money, and the CON agency, in response to its application, said, no, you can't. When an applicant for a CON is denied, in whole or in part, no matter what standard for prejudice the court uses, the denied applicant meets that standard. Whether you use substantial prejudice, person aggrieved, or affected person, Biomedical in this case meets that standard, and it is entitled to a hearing on the merits to assess whether the agency decision was in error. Now, the ALJ's final decision in this case should be reversed, and the case remanded for trial on the merits for two main reasons, either of which alone is sufficient to warrant reversal. One, because Biomedical's liberty and property rights were unquestionably prejudiced by the agency's decision because that decision directly prevented Biomedical from using its own money and its own property to run its business as it sees fit. And secondly, under the recent Forrest v. MPAC case from the North Carolina Supreme Court, because Biomedical is an affected person with a right of action under the CON Act, it cannot be required to show any additional injury in fact to be entitled to a hearing on the merits. But, and of course, that MPAC case, as we've argued in the briefs, abrogates the prior substantial prejudice case law, but in fact the court need not even reach that issue today because of the first reason, and that is that Biomedical's rights are substantially prejudiced as a matter of law.
Well, I have a quick question.
Yes, ma'am.
The appellees argue that you've not shown deprivation of a hearing because the court granted summary judgment.
I understand that they made that argument, Your Honor. We absolutely disagree with that because the ALJ disposed of the case entirely upon the substantial prejudice requirement under the APA and never reached the merits on the issue of agency error at all. And therefore, Biomedical has not been given a hearing to assess agency error. and today, the agency and TRC both contend that the court should ignore the recent MPAC case from the Supreme Court, and instead it wants the court to extend the prior substantial prejudice cases in the CON context to denied CON applicants. And if that were the case, then no denied applicant could demonstrate substantial prejudice, and substantial prejudice would turn into an insurmountable barrier, and that would effectively make administrative agencies that are subject to the Administrative Procedure Act unaccountable for their decisions. Now, very briefly by way of background, as you know from the briefing, this case involves two CO interviews, both of which were competitive reviews. Competitive reviews are a zero-sum game. Any station that an applicant is approved to bring into a county is a station that no other applicant can bring into the county. And in this review, in both of these reviews, the agency essentially determined that it was a tie, but it awarded all 10 stations that the other applicant, TRC, proposed to bring into the county to TRC, and for that reason alone, Biomedical was denied the ability to bring in all the stations that it demonstrated that it needed.
Do you agree that you have to have 10 stations in order to have a facility under the CON statute?
In the context of TRC, yes, we do. 10 stations is a minimum to establish a new facility.
Right.
Biomedical was not subject to that because Biomedical proposed to put stations at existing facilities.
So how do you respond to their assertion that if your proposal had been adopted, there would have been unmet need?
That's more nuanced than it would seem, Your Honor. And the reason is because it would have resulted in a remaining deficit under the planning process document, but that does not mean that there is an unmet need necessarily. First of all, it would only potentially roll over to the next application cycle where somebody could petition for another, there would be another opportunity potentially to apply to bring stations into the county at a later time. And second of all, every applicant, TRC and BMA included, don't just have to establish that there's a deficit of stations in the county. They also have to demonstrate that the proposal that they proposed is needed by the very patients they propose to serve. And here, Biomedical contends that TRC's proposals weren't needed at all because TRC proposed to put new facilities in counties where effectively they didn't even really serve patients already. They were proposing to build facilities in Guilford and Johnston County to serve patients that would have to come into the county to get there. So we don't believe that there would have been unmet need, Your Honor.
And you may not be able to answer this is a very broad question, but do you have any idea of the effect of the state's CON laws or CON program on the cost of dialysis services and the access to dialysis services?
I'm not aware of any data or any way to answer that question meaningfully in the context of dialysis. I know that there is a pending case before this court presently about the constitutionality of the CON Act as applied in another circumstance, but I don't think I should address those circumstances in this argument, Your Honor.
Thank you.
And so, as I said, Your Honors, the final decision we believe should be reversed in this case, first, because as a denied CON applicant, or denied in part, Biomedical's rights were substantially prejudiced as a matter of law. And this is the second argument that we addressed in our briefing, but I want to address it first because the court doesn't even really need to reach the Forrest versus MPAC case. So here, the agency used its discretion in the comparative analysis to pick the winner and the loser in these two reviews, and that decision directly denies Biomedical's freedom to relocate its own stations and spend its own money to better serve its patients.
So with the whole CON infrastructure, I mean, your client has put themselves in this position, and I'm just trying to get to where the property rights that you keep referencing. I mean, it's almost like they're using it as a sword and a shield. They don't want these folks to participate, and now you're saying that it's a property right that basically that the state's created. I guess that's the argument there.
Well, Your Honor, I think it's established that the CON program is an exercise of the state's police power. And any exercise of the police power is potentially a deprivation of liberty. That doesn't necessarily mean it's wrong, but that infringes on the regulated entity's liberty to otherwise do whatever they wanted with their own property. And so when that impacts a regulated entity like Biomedical, it has to have recourse to be able to question whether the decision was right or wrong. So we're not attacking the agency's ability to regulate and the agency's ability to make these judgment calls, but where those judgment calls impact our right to do what we want with our own property, that means we should have recourse to the courts when the agency gets the decision wrong. And so here, because the agency chose the winners and the losers, and to your question, Judge Griffin, because that decision directly prevented Biomedical from exercising its freedom to move stations wherever it wanted to, which it would be able to without CON regulation, that does prejudice Biomedical's liberty and property rights in those dialysis stations. And the APA, the Administrative Procedure Act, doesn't say a petitioner has to quantify its damages. It says a petitioner has to show substantial prejudice to rights.
So excuse me, so are you saying that you're prejudiced automatically upon denial of your proposal?
Yes, ma'am. I am saying that a CON applicant that is denied the ability to exercise, to do whatever project it proposes to do is substantially prejudiced as a matter of law. And that happens often in competitive reviews. It also happens in non-competitive reviews when an application is denied. But, and that's because the APA, because this is an administrative appeal, it's not the agency would have BMA, biomedical, quantify its damages, but this is not civil litigation where you have to establish damages with reasonable certainty. And as you know, ALJs don't even have the ability or the power to award damages from an agency decision. This court recognized last year in the Sound Rivers decision that substantial prejudice is an equivalent standard to being a person aggrieved under the Administrative Procedure Act, and that both of them are merely to establish standing. You may recall that we filed a memorandum of additional authority, which had a brief by the Department of Environmental Quality. We merely filed that to show that a state agency of North Carolina takes a similar view of the Sound Rivers and the MPAC cases, establishing that substantial prejudice is merely equivalent to showing that you're a person aggrieved that has been adversely affected by an agency decision. And Sound Rivers held that in administrative appeals, harm to a petitioner generally hasn't happened yet. And for that reason, the standard for prejudice is different than civil cases. And that case held specifically, quote, individuals who are adversely affected by discretionary agency decisions generally have standing. Otherwise, the burden of showing substantial prejudice would be nearly impossible, unquote. And so the bar is much lower than civil litigation. You simply have to show you're adversely affected. And here, there's no dispute that but for CON regulation, biomedical could move those stations tomorrow. And so the agency's decision directly prejudices those rights because it prevents it from doing just that. Now, of course, TRC...
And the relief you want is to go back and have a hearing.
I'm sorry?
And you want to have a hearing about it.
That's exactly right. We don't necessarily expect the court or ask the court to say that biomedical should get the CON or that TRC should. Biomedical is only asking for this court to remand this case for a hearing on the merits to determine whether the agency's decision was in error, and only then would we be entitled to get the CON. Now,
How would you explain the difference between prejudice and substantial prejudice?
Your Honor, the expression substantial prejudice has already been, as I touched on a second ago, substantial prejudice was referred to by the Sound Rivers case. But as far as prejudice and substantial prejudice is just the language that the General Assembly gave, and it's in reference to rights, not substantial harm. And so I'm not aware of anywhere in the APA where the language just refers to prejudice. I think that's just the term of art that the General Assembly used. But again, Sound Rivers made it clear that substantial prejudice merely means you're a person aggrieved, that you've been adversely affected. And of course, TRC and the agency point back to the prior substantial prejudice cases from this court in CON cases, and they say, hey, it's not good enough to show that your freedom to relocate your stations has been infringed. You have to show more than that. But remember, and we pointed this out in the briefing, but all of those published cases, in those cases, generally speaking, held that even where the petitioner is an affected person, as defined under the CON Act, that substantial prejudice under the APA is a separate substantive element. And on those facts, in those old cases, the petitioners there failed to meet the standard of showing sufficient harm. But you have to remember that every one of the published cases that has been cited involved a petitioner who was not an applicant for a CON. All of them involved non-applicants. And in those cases, even though the petitioners were affected persons, because the definition under the CON Act is broad, and it includes not only applicants, but also other healthcare providers that offer similar services in the area. So in those old cases, even though the petitioners were affected persons, they weren't the subject of the agency decision at issue. The decisions didn't prevent them from doing anything. And so it makes sense in those cases that this court would have required some heightened additional showing of how those petitioners' interests were harmed. But that is fundamentally different than this case where, again, biomedical was directly prevented from exercising its own business judgment to do what it wanted. And I think you know this already, but the standard that's used in substantial prejudice cases from this court is you have to show harm that is concrete and particularized and actual or imminent. That is the language that is used verbatim in the U.S. Supreme Court's Lujan case, which establishes the federal test for injury in fact to establish standing. And the Lujan case itself recognizes the distinction between the prejudice of somebody who is the subject of agency regulation and a third party. Lujan says, quote, "The nature and extent of facts that must be averred at the summary judgment stage or proved at the trial stage in order to establish standing depend considerably upon whether the plaintiff is himself an object of the action or foregone action at issue. If he is, there is ordinarily little question that the action or inaction has caused him injury." Unquote. So it's fundamentally different. And that distinction is recognized consistently in federal administrative case law. We cited in our memorandum of additional authority also the Parker versus District of Columbia case. That was a case about a challenge to DC's handgun restrictions. And in that case, the court held that the denial of a gun permit alone was not substantial prejudice, but it was sufficient injury in fact to satisfy that concrete and particularized injury standard. And the court said, quote, "We have consistently treated a license or permit denial pursuant to a state or federal administrative scheme as an Article III injury," unquote. Again, Article III injury being concrete and particularized injury. They gave several examples: denials of radio licenses, trucking licenses, hydroelectric permits, building permits, licenses to practice psychology. So it's clear that the denial of a permit or a license, or in this case a CON itself, the deprivation of that liberty is enough to establish sufficient injury to meet that standard. And of course, the agency and TRC in their briefing also cite to two unpublished cases, the 2016 biomedical case from Nash County and also the unpublished SCA case from, I think, 2014. We've addressed both of those in our briefing. Not only are they unpublished and therefore not controlling, but they're both easily distinguishable from this case. So here, the agency and TRC are asking this court to make a leap and extend all the prior substantial prejudice case law from this court, which all applied to non-applicants, and now import all those same requirements to disapproved applicants, which have been adversely affected by definition. And if the denial of an application doesn't constitute substantial prejudice and doesn't even allow a petitioner, entitle a petitioner to a hearing on the merits, then what does? And substantial prejudice then becomes an insurmountable barrier, and this is bigger than just certificate of need. If that is the standard under the Administrative Procedure Act, that substantial prejudice can't even be shown by denied applicants, then administrative agencies become essentially unaccountable, and that can't be the law. And it's troubling to us that the agency itself is taking the position that the very healthcare providers that it regulates have no right to question its decisions when they deny certificates of need. And so we believe, as a matter of law, an applicant whose application is denied, whether in whole or in part, has been substantially prejudiced because its liberty and property rights have been infringed. Unlike the case of a non-applicant, here no further injury is required. And so that alone warrants reversal for a hearing on the merits in this case without even reaching the MPAC case, but the MPAC case provides a separate independent basis. Under that case, biomedical can't be required to show any further injury in fact because substantial prejudice is simply a requirement for standing, as this court has recognized, and biomedical unquestionably had standing as an affected person under the CON Act. So let me back up a step. Under the CON Act, Section 131E-188, anyone who meets the definition of an affected person has a right to a contested case hearing. And as you know, the substantial prejudice language comes from the Administrative Procedure Act. And that distinction is important because all of the cases from this court in which a petitioner's appeal has been dismissed for a failure to show substantial prejudice, that is unique to CON cases. To our knowledge, that has never happened in any other type of North Carolina administrative case. But if substantial prejudice were a substantive element of a petitioner's burden under the APA, it would apply to all APA cases, not just CON. And so the question is, if substantial prejudice isn't a substantive element, well, what is it? Well, the answer to that question is standing. It's just standing. This court directly addressed that question last year in the Sound Rivers case. That's the first case where substantial prejudice under the APA has been discussed specifically outside the CON context. And this court held that substantial prejudice is simply a standing requirement equivalent to being a person aggrieved. Touched on this a few minutes ago. And it discussed it in detail in the discussion about standing, and the court discussed that prejudice and person aggrieved, those two terms were used interchangeably throughout that section about standing, and how those two concepts establish the petitioner's standing. And so, and as you know, the prior case law here has used a standing test. All of the prior CON substantial prejudice case law used the Lujan injury in fact test. Concrete and particularized, actual or imminent. That is the federal standing test that was adopted entirely by the North Carolina courts to establish substantial prejudice in the prior case law. And so even if the ALJ's final decision in this case, dismissing the appeal on the basis of failure to show substantial prejudice, even if it wasn't phrased in terms of standing, it amounts to a decision that Biomedical lacked standing to appeal the agency's decision. And we now know from the MPAC case that that conclusion was an error. MPAC discussed standing exhaustively under common law, federal law, North Carolina law, and it clarified the difference between legal injury and injury in fact. And MPAC discussed that under federal law, the Lujan injury in fact test applies to establish standing, but under North Carolina law, there is no equivalent to Article 3 of the federal Constitution, and therefore injury in fact alone is enough to establish standing.
Sure, yeah, before you got to your time, I was going to ask you about Living Center Southeast Inc. case. Is that one you're familiar with?
I'm somewhat familiar with it, Your Honor, but we didn't argue that. The opposing counsel argued as if we did, but it was never even mentioned in our briefs, but I'll try to answer your question.
No, I mean, it just seems to support your position almost, that it's saying that if there were two requests that were made that were competing, that they couldn't do summary judgment. They couldn't decide at summary judgment.
You're right, Your Honor. That principle is established by the Living Centers case, but I don't rely on Living Centers entirely, because part of the opposing counsel's argument is that when we get to a hearing on the merits, anything that we could possibly show wouldn't be enough to show substantial prejudice at hearing. And here, we believe it is absolutely the prejudice and the facts and the evidence to establish that prejudice are absolutely established already without question and not in dispute, because the agency decisions themselves say that Biomedical cannot move all the stations that it wants to move. That's on record pages 117 and 221, if you feel like referring to the agency's decision. I'm out of time right now, but I just want to reiterate before digging into most of my rebuttal time that the ALJ acknowledged that Biomedical is an affected person, but because she required additional quantification of harm, we believe that was error under the standard as now articulated by MPAC, in that additional injury in fact cannot be required. And so here, no matter what standard the court chooses, Biomedical met that standard. It's an affected person under the CON Act because it was an applicant. It's a person aggrieved because it was adversely affected by the agency's decision, and its rights were substantially prejudiced because it was denied the liberty and property rights to do what it wanted with its stations. And obviously that doesn't mean that the agency decision would be reversed, but Biomedical is entitled to a hearing on the merits.
Thank you.
Judge Zachary, I apologize, but because of the glass, I really can't see you. I could see Judge Wood and Judge Griffin, so if you...
I've gotten that impression.
Okay, if you're trying to get my attention, I apologize that I can't see you very well from up here. Good afternoon, Your Honors, and may it please the Court. My name is Lee Whitman. I'm the attorney for Total Renal Care of North Carolina, which is the appellee along with the Department of Health and Human Services in this case. My colleague Derek Hunter is here on behalf of the Attorney General's office, and we're the appellees in this case. If I could, I would like to use 20 minutes of our 30 minutes on behalf of TRC, and Mr. Hunter will argue the remaining 10 minutes on behalf of the Department of Health and Human Services Certificate of Need section. Now, By way of roadmap, Your Honors, if I could, in my arguments this afternoon, I would like to demonstrate to you that standing to file or commence a contested case does not equate to establishing substantial prejudice under 150B 23A of North Carolina law. And I'll use three main points to establish this for Your Honors. First, picking up where Mr. Hewitt left off, BMA attempts to extrapolate logic and findings from two non-certificate of need cases, the Impact case and Sound Rivers, to argue that no injury in fact must be proved by his client. And there's a reason that those are his two primary arguments, because we respectfully submit BMA has no injury in fact in this case. And to the extent they did have any harm from the denial of 2 stations in Guilford County and 2 stations in Johnson County, that harm did not rise to the level of being substantial as contemplated by 150B 23A, as interpreted and applied by this court in many appellate decisions over the past 25 years. Second, I will show to Your Honors and demonstrate that the North Carolina legislature has expressly distinguished and not confounded the concepts of substantial prejudice and person aggrieved under the Administrative Procedure Act, and that the legislature has expressly directed that while a person aggrieved may commence a contested case, that petitioner still has, after commencement of the case, the burden of proof to establish the facts required by 150B 23A by a preponderance of the evidence. Third, despite its obligation to establish substantial prejudice by a preponderance of the evidence, and that's specifically pursuant to 150B 29A, Your Honors, a statute not addressed by any of the briefing offered to you by BMA, not addressed in any of the oral arguments that person aggrieved or affected party is exactly the same as substantial prejudice. That statute alone decimates both of those arguments. What Mr. Hewitt's been arguing to you, what his appellant brief and his reply brief are all about one thing: standing. Nobody contests in this entire case that his client met the definition of an affected party under 131E 188A because it was an applicant in the case. So, pursuant to the Administrative Procedure Act, his client could commence the action. They did that. But as with in any lawsuit in the state of North Carolina, after you commence the case, you have a burden of proof. You must prove your case. You must prove the essential elements of your case to succeed. In this case, it's very simple. In any certificate of need case, it's very simple. The standard is in 150B 23A. And it states 2 different things have to be proved: agency error and that the agency's decision substantially prejudiced a right of the petitioner. The case law of this very court, going back 25 years, starting in Brithaven in 1995 and coming all the way forward, conclusively and consistently establishes that both of those essential elements must be met. The case law of this court further establishes that the administrative law judge at OEH has the power, expressly has the power under the APA, under 150B 33 and under 150B 34, to dispose of cases in their entirety under Rule 56 at summary judgment stage. Now, when you put all that together, and these are not mystery facts by those of us that litigate certificate of need cases at OEH, you know when you file a certificate of need case, those are the 2 things you have to prove. It has nothing to do with standing. Standing here is not disputed. And I take sharp exception to the broad comments made by my colleague that Impact and/or Sound Rivers stand for the fact that because you are an affected party or a party aggrieved, you've established substantial prejudice. Your Honors, respectfully, neither of those cases say that. They don't come close to saying anything close to that. Let's take them each in order. The Impact holding was not that a person aggrieved equals substantial prejudice. It wasn't that at all. It was that a plaintiff is not required to show injury in fact to demonstrate standing under the North Carolina Constitution when the legislature has statutorily conferred standing on that plaintiff. But what's been left out in the briefing and discussion is that only applies if the plaintiff, here petitioner, is within the class of parties intended to be protected by the statute, and that test is only used when there is a standingless cause of action based purely upon public rights. Now, that is not this case. And the impact case, which is relied so heavily by BMA in its appellant's brief and its reply, is easily distinguishable from the present case. First of all, it didn't even exist at the time this case was litigated, the decision. But it's distinguishable because if you read that case, please read impact. It does not stand for the proposition that my colleague states. It does not even mention certificate of need law. It does not mention the term affected person under 131E, 188A. It does not mention the concept of substantial prejudice. It does not reference or deal with a petitioner or a plaintiff's burden of proof as a petitioner after they have standing to sue. It doesn't talk about 150B-29A, and neither does BMA, because it ends their case. Finally, the impact holding does not abrogate or otherwise overrule Parkway Urology, Britt Haven, all the CON cases that this court has developed over the last 25 years. That is stated in the briefs and the reply brief as if it's a fact. I'll tell you where it's not stated. It's not stated in the subsequent history of Parkway Urology, Britt Haven, SCA, no subsequent history indicating that the impact holding has abrogated, overruled, or changed this court's analysis in certificate of need cases with regard to standing versus the duty to prove by a preponderance of the evidence both of the facts, separate and independent facts, agency error and substantial prejudice resulting from the agency's decision. Now, respectfully, Your Honors, the easiest way to demonstrate that there is a difference here is to look at the legislative history, and that really came to light, crystallized this week or at the end of last week when BMA filed a supplement to the record, and we filed a supplement to that supplement. What that does, if you look at the session laws that were contained in what was added to the record by the parties, you will see something very, very clear. You can connect the dots. The North Carolina legislature has never conflated the terms person aggrieved or affected party with substantial prejudice. Never. What those session laws show, and I'll connect the dots for Your Honors. One, Session Law 1985-746 added the concept of substantial prejudice to 150B-23, effective January 1, 1986. That's where it came from. The legislature did that. Less than 2 years after that, the legislature passed Session Law 1987-879, and it added that sentence that you see at the end of 150B-23A, which says this: any person aggrieved may commence a contested case hereunder. So in less than 2 years, the legislature adds the concept, the requirement that you prove substantial prejudice in 150B-23, and then states and clarifies and distinguishes that if you're an affected party, person aggrieved, you can file, you can commence the action. Your Honors, respectfully, there is an enormous procedural and substantive difference between standing to file a suit and proving your case, proving the essential elements of your case. And that's where the third piece of this puzzle becomes so important. In Session Law 2000-190, the legislature specifically added 150B-29A to say what? Quote, the party with the burden of proof must establish the facts required by 150B-23A by a preponderance of the evidence. Your Honors, if what my colleague has argued is true, there would be no need for the substantial prejudice prong of 150B-23. It would be irrelevant. The fact that you can file the suit as an affected party or a party aggrieved would eliminate substantial prejudice. That's not the law. And we can see in 150B-29A, the subsequent requirement after the action is commenced, what does the GA say? The General Assembly states, you with the burden of proof, the petitioner, you must approve the facts required by 150B-23A. That's substantial prejudice, and that's agency error. Your Honors, respectfully, that completely destroys the case that BMA has presented to you in its appellant brief and its reply and the oral arguments here today. There is a distinction. Standing is not substantial prejudice. Impact does not say that. You know what other case doesn't say that? Sound Rivers. Sound Rivers doesn't say that at all. It doesn't even say anything close to that. What this court said in June of 2020 when it looked at the Sound Rivers case, and there's been a lot of discussion about Sound Rivers, and it's on appeal to the North Carolina Supreme Court right now, but that was not a certificate of need case. It was a challenge to the Department of Environmental Quality's issuance of a wastewater permit, and the holding there was not that if you're a person aggrieved under the APA, you've established substantial prejudice. That's not what the case says. It's not even close. What it said, what this court said there was petitioners in that case who were from water protection agencies, water protection groups, could use the same type of evidence to prove substantial prejudice as they did to prove that they were persons aggrieved. But what did this court say? It didn't stop there. That's where BMA likes to stop. This court didn't stop. It said, so long as the evidence is considered within the context of the organic statute, there the Clean Water Act, here the Certificate of Need Act, to determine whether the plaintiff has demonstrated substantial prejudice under 150B23 and the statute that I've been talking to you about, 150B29A. So that is a very far cry from saying that if you're a person aggrieved under the APA, you've established substantial prejudice. In other words, what this court stated was that petitioners, and this is the language of the Court of Appeals, petitioners' claimed uses and interests in the water that was at issue in that case could form the basis for substantial prejudice if those plaintiffs met their burden of proof under 150B23. Now, I heard commentary about whether this is an impossible standard and it makes it so hard to do. That's not the case at all. We can look at Sound Rivers and see the petitioner there had no problem proving substantial prejudice. What did they do in that case? The petitioners in that case came forward with evidence. They had affidavits. They gave testimony at trial, and they stated that we use the waters for this purpose. We have businesses along the borders. If this particular amount of if this wastewater permit is allowed, it will change the nature of our body of water as a swamp. And there was also evidence of financial injury, loss of permits, loss of fees associated.
Mr. Whitman, even if they're, say the argument for substantial prejudice is weak, I mean, why don't they get to make that argument at a hearing?
Your Honor, they did get to make that argument at the hearing. We had a hearing. Do you know what we've had since they filed? The CONs in this case were issued in December of 2019. Well, they weren't issued. The decisions of the agency to grant the certificate of need applications filed by my client were issued in December of 2019. I'm standing before you 2 years later, arguing that my client should be able to develop facilities that provide services that the State Medical Facilities Plan and the SHIC and the governor determined were needed by patients in Guilford County and Johnston County. It's been 2 years and counting. Why? Because they filed petitions for contested case. They're an affected party. They can file. But after they do that, Your Honor, they have to prove what is the substantial impact of this decision. And I'm glad that you asked me that, because let's examine what the harm is here, what they claim. They claim this case is not about competition. They don't want you to think that, because they know the case law of this court is that normal enhanced competition is not substantial prejudice. So they've gone far away from that, even though the allegations in their petition for contested case, 3 out of 4 are about competition. But let's look at why. Why did the ALJ get to the conclusion she did? Because she analyzed the facts in this case. And the facts in this case, none of these, you didn't hear any of these details, any of these facts, any of these numbers in the appellant brief or in the reply, but these are undisputed facts that BMA was the predominant provider in Guilford County. 7 facilities, 235 stations already in operation there at the time these applications were filed. You did not hear in their brief or in their reply or in argument today that they are the exclusive, the only provider of dialysis services in Johnston County with 5 existing facilities and 90 stations approved. You did not hear them say that their proposal to get 4 additional stations to the West Johnson facility in Johnston County, which would have, by the same token to the question about TRC having to file for a 10-station facility, if that had been approved and TRC denied, then that would have, just those 4 stations alone would have prevented TRC from coming into the county. But, Your Honors, what they got 75% of what they asked for. They got 12 of the 16 stations they petitioned for. This is not a denial of what they asked for. The Certificate of Need section, and Mr. Hunter will talk about this, did exactly what it's supposed to do. What does Sound Rivers tell us? You've got to look at the organic statute you're dealing with and interpret substantial prejudice within the context of that organic statute. The organic statute we have is a Certificate of Need law. Unlike Sound Rivers, where the plaintiffs were the target group that the statutes were intended to benefit, the Certificate of Need section takes its actions to review proposals for new institutional health services to do what? Protect market share of providers? No. Health, safety, and welfare of patients and residents of North Carolina. Those are the intended beneficiaries of the Certificate of Need law. And they did it in this case. There's no question, there's no dispute that they found both applicants, TRC and BMA, completely conforming on all statutory review criterion, completely the same in the competitive review. And so what did they do? They made a decision that would allow patients in Johnson and Guilford counties and their surrounding service areas to have the full set of services under the deficits identified in the SMFP. If BMA's proposals had been approved, then there would have been a continuing 8-station deficit in Greensboro and a continuing 8-station deficit in Johnson. That does not best serve the interests of health, welfare of residents of those counties or surrounding service areas. The Certificate of Need section performed that review, and back to your original question, Judge Griffin, there was significant review of that decision. They filed their petitions, we had a hearing in front of the judge on a motion to compel, we had to give a bunch of documents related to our patient letters, we had a hearing in front of Judge Bodenheimer for that, we had multiple depositions, we both filed petitions, motions for summary judgment. Now don't forget that. They're over here saying how entitled they are to a hearing. They filed for summary judgment, just like we did. They also filed for summary judgment on one of the agency error issues, and they didn't get it. They keep referring to Judge Bodenheimer saying, well, there's an issue of fact on that. That's an issue of fact on a motion for summary judgment they filed on agency error. So they can't bootstrap their own the denial of their own motion into saying that they should get a full contested case hearing. You don't get a contested case hearing under this state, under the organic statute of the Certificate of Need, if you cannot prove substantial prejudice as an essential element of your claim. And the ALJ properly determined, for the reasons in the record, that they failed to do that. And we respectfully ask your honors to affirm that decision. I turn over the lectern to Mr. Hunter.
Thank you.
May it please the court, your honors, I'm Derek Hunter of the Department of Justice on behalf of the Department of Health and Human Services, and with me is my co-counsel, Kimberly Randolph, also of the Department of Justice. Your honors, my learned colleague, Mr. Whitman here, has done an excellent job of explaining to the court why, based on the plain language of NC Gen Stat 150B-23, and 25 plus years of appellate precedent, why substantial prejudice is a separate and independent element of a petitioner's claim under the APA, under the Administrative Procedures Act. And the failure to prove substantial prejudice is fatal to a petitioner's claim for relief. Mr. Whitman also showed why the appellate, BMA, failed to offer any evidence of substantial prejudice of any kind, be it via a fact witness, an expert witness, a Rule 30b-6 witness. There was no data, no analysis, no report, no evidence quantifying harm, no other documentation produced in discovery, no attachment to its motion for summary judgment, no attachment to its response in opposition to the appellee's motion for summary judgment, no attachment to support the less than 1.5 pages of the 25-page brief it submitted to this court that is dedicated to substantial prejudice. Nothing. Now, contrary to Mr. Hewitt's argument that the legislature that the term substantial in substantial prejudice is simply cursory, It is presumed, the legislature is presumed to have known the meaning of the language that it uses in enacting a statute. And the courts must give each word its intended effect. 150B-23 says specifically that a petitioner must prove substantial prejudice. So that is what must be proven. But even separate and apart from the 20-plus years, 25-plus years of legal precedent that establishes that substantial prejudice must be proven, I will attempt to highlight the lack of substantial prejudice in this case from a practical, real-world standpoint. Simply stated, Your Honors, individuals with end-stage renal disease or kidney failure have two options: either a kidney transplant or dialysis, or they will die. It's as simple as that. So here's what the agency was faced with in this review. The July 2019 semi-annual dialysis report contained a 20-station deficit in Guilford County and a 12-station deficit in Johnston County. In Guilford County, BMA proposed to relocate 12 stations into Guilford County, and TRC proposed to develop a new 10-station facility. At the time of the review, BMA was the predominant provider of dialysis services in Guilford County, having been previously approved to operate 235 stations, which amounted to 80.5% of all of the stations in Guilford County. TRC did not operate any dialysis facilities in Guilford County. Now, an applicant proposing a new facility must propose at least 10 stations. So despite the record evidence that BMA proposed to develop just enough stations to prevent its competitor, TRC, from entering Guilford County, the fact is that the agency had before it two applications that were both found fully conforming with all statutory and regulatory review criteria, and they were determined to be comparatively equal to one another. If the agency had approved the BMA application as proposed, as Mr. Whitman stated, there would have remained an 8-station deficit in Guilford County. However, in approving TRC for a new 10-station facility and granting BMA 10 of the 12 stations it proposed, the agency fully met the need for life-saving dialysis services in Guilford County, as identified in the semi-annual dialysis report and as enacted by the governor. In Johnston County, the SDR identified a 12-station deficit. BMA proposed to relocate 4 stations to its Johnston County facility that was not yet even open or operational. Now, a dialysis facility that needs additional stations on its own can apply under the facility need methodology. However, if the facility is not yet operational, there is no way that it could demonstrate need for those additional stations. In Johnston County, similar to Guilford County, TRC proposed a new 10-station facility. BMA was the sole provider, the only provider, holding 90 certified stations in Johnston County at the time of the review. Now, similar to Guilford County, despite evidence that BMA proposed to develop just enough stations to keep its competitor out of Johnston County, the agency had before it 2 applications that were fully conforming with all statutory and regulatory review criteria and that were comparatively equal to one another. The agency approved TRC for the 10 stations and approved BMA for 2 of the 4 stations that it proposed. Had the agency approved BMA's application as proposed, there would have likewise remained in Johnston County an 8-station deficit. Rather, the agency fully addressed the unmet need for life-saving dialysis services in Johnston County, just as it did in Guilford County. The agency's decisions were not made in consideration of an entity's market share or competition, although the CON law contemplates the benefits of increased competition in statutory review criteria 18A. Further, in the agency's comparative analysis, a new provider in a service area, in this case TRC, is determined to be the most effective alternative to an existing provider for the reasons detailed in the statute. Again, here, the agency, based on its analysis of the applications in light of the statutory criteria, a comparative analysis of the applications, and ultimately what was in the best interest of the health of the citizens of Guilford and Johnson counties, awarded 10 stations to TRC, 2 of the 4 stations to BMA. Again, fulfilling in its entirety the need for dialysis stations in those 2 counties. And in so doing, even though BMA offered no evidence of substantial prejudice whatsoever, BMA argues to this court that the agency, having not approved it for 2 of the 12 stations it proposed in Guilford County, which amounts to less than 1% of its approved stations, and not approving it for 2 of the 4 dialysis stations it applied for in Johnston County, which amounts to less than 3% of its approved stations in Johnston County, amounts to substantial prejudice. I would submit to the court that under no logical or reasonable circumstances can such an outcome, which fully addressed the life-saving healthcare needs of the citizens of 2 counties, identified in the semi-annual dialysis report, the SMFP, and enacted by the governor, amounts to substantial prejudice. Mr. Hewitt made a reference to BMA being denied the opportunity to operate as it sees fit. Well, that runs completely counter to the Certificate of Need law. The very premise, the fundamental purpose of the CON law is to limit the provision of healthcare services in a geographical area to those that are needed and therefore cost effective. So substantial prejudice, as Mr. Whitman has laid out for the court, is an essential element of BMA's claim under the Administrative Procedure Act. And failure to prove substantial prejudice is fatal to BMA's claim for relief. In addition, in arguing the substantial prejudice issue, the petitioners failed to show substantial prejudice in any way other than competitive harm. And that has been, competitive harm has been categorically rejected by this court as a means to establish substantial prejudice.
Well, I believe that your colleague argued that it wasn't that they were trying to avoid competition, but that they felt like they were being hindered in their right to move their equipment to where it's needed.
And that's just a red herring, Your Honor. If you look at the petition, as Mr. Whitman pointed out, 3 of the 4 allegations relate to competitive harm. So it's a means of avoiding that argument at this stage of the proceedings because the court has already categorically rejected.
Would you say that's just part of the Certificate of Need operation?
Is what? Just a part of Certificate of Need operation, sir.
That you can't move anything you want wherever you want it, your equipment?
That is absolutely right. The premise of the law is to only allow healthcare services in geographic areas where there's been determined by the State Health Coordinating Council and the governor that there is a need. Moreover, in the Sound Rivers case, in this very court, after the Sound Rivers decision, these very same lawyers, Mr. Whitman, myself, Mr. Hewitt, Ms. Hedrick, we argued the Mobile Imaging Partners case, and in that case, this court held that the long-standing precedent in Certificate of Need cases that substantial prejudice is an independent element of a claim separate and apart from showing agency error. So with that, Your Honor, the administrative law judge committed no error in granting the department and TRC's motion for summary judgment, committed no error in denying BMA's motion for summary judgment, and the court should affirm the administrative law judge's decision. I'm out of time, but I'm happy to answer any questions if you'd like.
Oh, thank you.
I'm set. Thank you.
Thank you.
Thank you, Your Honors.
Mr. Whitman was right. I can't see Judge Zachary very well. So.
Well, you can hear me, though, so we'll be all right.
Yes, ma'am. If I may, I want to address the tail end of Mr. Whitman's argument and Mr. Hunter's argument first. And generally speaking, I understand them to be arguing that the effect of this decision on BMA, on biomedical, is simply part of the CON process, and that the CON regulatory scheme worked as intended here and did what it is designed to do. And the effect is just a natural outgrowth of that. However, that entire argument confuses the issues of substantial prejudice on the one hand and agency error on the other hand. What they are arguing is that there was no prejudice to biomedical's rights because the agency got the decision right, because more people needed stations and they wanted TRC, they made the right judgment call in allocating stations to TRC and not biomedical. Maybe that's correct. Maybe the ALJ, had the ALJ conducted a full hearing on the merits and had heard evidence, and maybe the ALJ would have gotten to that conclusion at the end of a hearing on the merits. And if that's correct, then we lose. But that, again, conflates the issues of error with prejudice, because we believe, and we argued and alleged in the petition, that TRC's projects were not needed, that TRC didn't meet any of the regulatory criteria, including the fact that its patients actually don't need to go across county lines much further from where they currently live to get dialysis. And so if we're right, and if the agency got it wrong and denied biomedical the ability to move some of its stations because it erroneously approved the other applicant, then biomedical has to have a recourse to the ALJ, to this court, to correct that error.
But okay, I'm not sure I understand where you're going with this, because it seems to me that there was no other way for the ALJ to rule to meet the deficit. If the ALJ granted your client's proposal, there would have been a deficit. Am I correct?
There would have been a remaining deficit of dialysis stations in those two counties. That's
So
correct.
is it your contention that that deficit, that there really wasn't that deficit? That the
I wouldn't say
deficit
that.
was
I wouldn't say
incorrect?
that, Your Honor. But the clarification that I would make here is that there is absolutely zero requirement under the regulatory scheme that there cannot be a deficit. None. A deficit only does one thing. It allows for opportunities for existing providers to add stations, to file an application to add stations. Sometimes it allows for opportunities for providers to bring in stations from other counties. But there is no requirement under the Certificate of Needs regulatory scheme that there can't be deficits. As a matter of fact, if you look at the State Medical Facilities Plan, you will see deficits in many counties. Other counties have surpluses. That's just the state of affairs, and it's constantly evolving as the State Health Coordinating Council updates their data every year. And so saying that the agency was eliminating the deficit, yes, it was. And again, that might have been the right outcome. But if it was the wrong outcome and it was only achieved by approving an application that wasn't eligible because it didn't meet all the criteria, and the effect of that was that biomedical can't do, and let me point out again, that there's no dispute here that biomedical's project was needed. The agency itself determined that biomedical, all the stations it proposed to move were needed by its patients, and that it met all of the requirements. That is in dispute with respect to TRC, but not with respect to biomedical. And if we're right, and the agency denied biomedical the ability to move stations because it erroneously approved TRC, then there has to be recourse for that. Because again, that denies biomedical the freedom it would otherwise have to allocate its stations where it wants. And I will say also that there's been arguments made that the ALJ determined that biomedical only applied in order to block competition from TRC. There is no finding in the final decision as to that. And again, the final decision actually agreed with the agency, or excuse me, that there was no issue as to biomedical's conformity with all of the review criteria. Biomedical's project was needed. And as to the idea of it being a red herring about the type of prejudice, Judge Zachary, your question to Mr. Hunter at the end of the argument, that's dead on, Your Honor. Biomedical's petition initially did reference a lot of different things that could have been harm or substantial prejudice to its rights. But throughout the briefing at trial, at summary judgment rather, and in this court, Biomedical has never once relied on increased competition. The harm that we're using as the basis for substantial prejudice is our own right to control our property and our liberty otherwise to develop and allocate our stations as
Don't you lose some of that when you get, you interject yourself, your client interjects themselves into such a heavily regulated, or strangely regulated field here? It kind of loses some of that, hey, if I don't want my property tied up in this, I'm not going to get in this.
Yes, but the trade for that is in trusting that the agency will do it right and according to the law. And when the agency takes away your rights and they don't do it according to the law, there has to be accountability. And the standard that they're advocating for quantification of harm to show substantial prejudice to rights, that is a slippery slope. We think there is zero dispute here. As a matter of fact, again, conclusion of Law 82 in the final decision acknowledges that we were denied the ability to relocate stations. And to require quantifiable financial injury on top of that, not only is it not required by the APA, Sound Rivers discusses that that's not required when you're the subject of regulation. Lujan says when you're the subject of regulation, you don't have to do that. But in addition, what about the restaurant owner who applies for a liquor license and only gets approved for beer and wine but not liquor? So do they then have to bring in an expert witness to quantify the injury to their business before they can challenge that? That's ludicrous. And so this would establish a standard that would make the agency utterly unaccountable, and not just CON. That's APA. We're talking about all administrative agency decisions. And so we have to separate the issues of agency error from the issues of substantial prejudice. And here, unquestionably, the denial of liberty was substantial prejudice to its rights. I'm happy to answer any other questions you have.
Thank you.
I'm set. Thank you.
Thank you very much. That concludes oral argument in this matter. I want to thank you both, or I'll thank you, all three of you, for your excellent arguments, and we'll take this matter under advisement. Mr. Sanders will adjourn.